Mr. Pohren, you may proceed.
Thank you, Your Honor. May it please the court, my name is Ed Pohren. I'm an attorney in Omaha, Nebraska. I've been pro hoc viced to be present before you. With me is Aaron Schmiel. Mr. Schmiel is the Iowa attorney that has sponsored me. I appreciate the opportunity to be here on behalf of my clients, and we will hope to educate the court as best we can on these issues. There are three that we wanted to talk about today, and the first has to do with statutory construction of a part of the Iowa Civil Rights Act at Chapter 216, and specifically 216.6, Parent 6, Parent A. And that has to do with an exception for the small businesses from the parameters of the Iowa Civil Rights Act. The second issue we want to talk about today is whether there was sufficient evidence that Ms. Cote adduced to overcome the summary judgment motion directed at the statutes of limitation. And then the third issue that we wanted to address today has to do with the made of intentional infliction of emotional distress, and specifically the finding of outrageous conduct, which the trial court and the Court of Appeals made or affirmed. The case has one of first impression when we get to the first of the issues to be argued, and that is that the court's never had to address whether it's Iowa Code Section 216.6, Parent 6, which includes the exception and specifically the family member portion. As the court is aware, Section 6 says any employer who regularly employs less than 4 individuals is exempt from the Iowa civil rights law. Section A goes on to say, for purposes of this subsection, individuals who are members of the employer's family should not be counted as employees. 6 also has a subpart B and a subpart C, where the phrase employer's family and members of the employee's family are found. And so the first challenge before the court is to determine if the Iowa Court of Appeals and the trial court correctly deduced there was ambiguity within this statute, and specifically in the phrase employer, where employer is used in conjunction with family. Employer includes person under the definitions of the Iowa Code. Person, as defined in the Iowa Code, includes individuals. It also includes partnerships, corporations, trusts, and a number of other types of entities.
All right, so who is a family member of a corporation? You know, I want to explore the business that I think motivated the courts below, and they're trying to figure out how do we apply this to a corporation.
Well, and I think the answer really comes down to a case-by-case analysis and not a hard and fast rule, which is what the lower courts applied. What I think the task here for this court, as given by the legislature, is really to say, how do I determine what is a member of a family, not to categorically rule them out. I think this case actually provided the trial court and the Court of Appeals and this court a perfect opportunity to do that, because this particular employer, the corporation, is a sub-S corporation owned by one individual, Patricia Dorn, and for purposes of Iowa law, it's a pass-through for tax purposes, and it's recognized.
But where does Section 216 distinguish between sub-S corporations and regular corporations?
And it doesn't. I would love to be able to tell you that the Iowa legislature had some language in there, but it doesn't.
And people incorporate to take advantage of liability protections, and there's some tax differences, and there's other reasons people incorporate, and then there's some detriments. And you know, it seems to me you're saying, well, we should get all the benefits of incorporating, but not the detriment. And I don't read that in the statute because person is a corporation.
Well, and I think what we're trying to figure out is what is the intent of the legislature when this was put forward as...
I mean,
as the
before
law.
we get to intent, I mean, I'm kind of a plain language guy, and it says in the statute, individuals who are members of the employer's family don't get counted. Well, if you're a corporation, maybe you don't have any individuals who are members of your family, and that ends the case, right?
Well, but that would be the same to be said then for all of the term employer, because employer does encompass person.
But employer can encompass a corporation
Can.
throughout the statute. I agree with that part of your analysis. I agree with, but a corporation doesn't have individuals who are members of its family. You need more than just employer, including a corporation. You need for this exception to be applicable, you need to have individuals who are members of its family, and a corporation doesn't have any, right?
But I think the answer is, in looking at statutory construction, Your Honor, what we're looking at here is the same word being used within the same paragraph. This court's already said that in interpreting a statute, if the word is used, it's got to be given the same type of an interpretation throughout the
Unless
law.
the context requires otherwise, and here, how can a legal entity, a corporation, have family members?
I think that what you're looking for is to try to interpret the intent, and that's why I brought in subparts B and C, because...
You don't get to intent unless it's ambiguous. And tell me how it's ambiguous.
My point is that I don't think the term employer is ambiguous. I think the court has to look at employer when it's used and interpret it in the same way and in a consistent fashion. And to do that, you would interpret employer to include all corporations, trusts, individuals. And I'm looking at this statute and I'm saying to myself...
But the code defines employer as any person who any person employing employees, and then they define person as corporation. They have their own definitions in here.
They also say that it includes individuals, it includes trusts, and so forth. So you can't really separate out and say under subpart A, first sentence, employer means what the statute says it means, but then come down to the very second sentence of the same subparagraph and then interpret it differently. And my point is that in all of the people who have corporations, they have family businesses, they interpret this particular employer meaning that it includes families. Small businesses are full of these kinds of entities.
Are there any cases from other states that have interpreted a similar statute your way?
No, because they're just, this happens to be a very unique statute. Looking around at all the other types of Title VIIs, they don't interpret the way Iowa does. Iowa designed this in a different way all the way back in 1964.
What is the purpose of allowing of not counting family members?
Well, what they're trying to is say here, in my judgment, the legislature looked at this and said, if you have a small business that includes people within your family, we're going to take your family members and set them aside and not count them, and we're only going to look to who are the other employers that this employer employs. And as the drafters were looking at this, it seemed apparent to me that they were trying to say, that applies whether it's a corporation, whether it's a trust, whether it's a partnership, and later you would say LLCs as well. And so you look at it and you say, what the legislature gave us as the task for courts is to say, I'll look at this and I'll say, in the case of a corporation, who is the owner? And it doesn't, trial court and the Court of Appeals got into whether it includes boards of directors and so forth, and I don't think that's the case. I think it's the owners of a small business. And to the extent that the owners of a small business can be separated out, that's what courts do. And in fact, that's what the Iowa Civil Rights Commission has been doing since the time it was first charged with the statute. So you look at it and you say, okay, it's a small business, it's a small corporation, I'll exclude, in this case, the owner and her family member. And her family member at this point is her husband. That's not a hard task for a court to do, and I think that's the task the legislature was giving us. Not a hard and fast rule that simply said, I'm not going to allow.
What about a grandniece?
Well, that's what I said in the materials I gave you. I said that's what Isabella sent Columbus around the world for. You got to chart waters, and in this particular case, whether the grandniece is or is not is something for the courts to decide. And in this particular case, the issue for grandniece may not be whether she's a grandniece. The issue may be whether the employer regularly employed her. And I think if this case gets sent back to the trial court, that is one of the issues that the trial court would be tasked with in its analysis.
Has the Iowa Civil Rights Commission issued any rulings that on this issue?
None that I'm aware of. It's on a case-by-case basis, and in fact, if you go back in the record in this case, they actually talked about this particular entity and understood that it was, they didn't give it that interpretation. They didn't say it's excluded. They basically said, we will, if I remember it correctly, we will not include the wife and the husband, and then they would have included other people.
So we noted in our Baker decision and again in Simon Seating that the purpose of exempting employers who employ fewer than 4 people is to recognize the freedom of association in small, close-knit groups. Do you think the legislature intended employers to lose that freedom merely because they incorporate? I
don't, and I looked at Professor Barfield's nice article from way back, and there's just no guidance there. Not in his article. If you were to call him on the phone, he'd probably tell you the same thing. There is no guidance that he had then, and we have now from his article. What you look at, though, is the general intent. And the general intent of the legislature, it was, I think, fairly clear. We want to provide for free association, and I don't think they were considering it just free association from a small proprietorship. I think they were considering free association to be part of the way Iowans and others have done business for decades, and that included, small corporations and partnerships and all those other elements that go into what is a person. To the extent that the second issue, I think, becomes important, it actually, I think, becomes more important after the Court of Appeals ruled in this case, and that is because what we're looking at is what is the quantum of evidence that's necessary to overcome a claim based on the statute of limitations. And in this case, to go backwards with facts, the court will recognize that during the 300 days preceding Ms. Cote's filing with the Iowa Civil Rights Commission, she does not allege that there is one demonstrable act that occurs in that period. The last period that she finds in any of the evidence that's before the court that you can see is sometime in March of 2012. And as the court noted at the trial court level, probably April, I should say June 12, I believe it was the time when the court said, the 300 days would expire. For purposes of the 300, for the 2-year statute of limitations, it would have been a date in April. So whether you look at the state at the 300 days or the 2 years, there is not any discrete act that takes place in that time, and the only time that there is a discrete act precedes that, and the last one mentioned is in March of 2012.
Could a fact finder infer when he comes around and hovers, although she doesn't look down, that would have an emotional impact on her, or does the fact finder need to infer that his fly was open?
No. What I think the fact finder needs is some kind of evidence. This is a claim that begins with he harassed. You need to find that there is some kind of an overt act, not a feeling that somebody has that he's going to do this to me. There has to be something that the harasser does. And in a particular case like this, it's more than just he walks in the same area I am.
Well, but the evidence is a little more than that, I think. And please correct me, but the evidence was that she didn't look down to observe, as Justice Waterman is saying, but that he came at the same time of day in the same work area where he really didn't have I mean, the MO was virtually the same. The one thing that was different, and maybe it's determinative, but she didn't look down and make any observations. I mean, I think it's an inference. I mean, there's no direct evidence, I think. But can a jury infer that this was part of the overall harassment scheme?
I don't think you can infer that based on a subjective feeling by the person who is claiming to be harassed. I believe that when you accuse and when there is a harasser, there has to be something overt that he does.
Might even be right. It's not a subjective judgment, but how about objectively? I mean, this fellow has a tendency to appear at certain times of the day when he doesn't have a particular business reason for being there, and here he is, and she just doesn't look down. Can one believe that there's something to go to the fact finder based on that act?
You added an element that's not true, and you asked me to correct you if you're wrong.
Of course, but
And so I'm going to indulge and I'm going to say he has a legitimate business reason for being there, and the facts are replete with that, because this is a small room that you walk into from the door, and right over here would be her desk, and she's a receptionist. Behind her desk over here, you walk past her, she's got her chair, and all this way and over here are all of the business machines of the entity, the copiers, the fax machines, all of the files, all of the materials that they use in their day-to-day operations. It's got the money that they collect. That's where everything takes place. He gets to work all the time around 8 o'clock. He's never deviated from that. That's been his MO, and that's been the evidence. He's got a legitimate reason to go up there and to use those machines and to be in her presence. And if she's the only one and he asks her a question, he's got the same right to ask a question as anyone. What I find to be interesting in this case is that if Ms. Cote says, I saw him coming and I looked away. Well, when he was coming, we don't have any evidence as to, was his fly open if she looked at him? She doesn't say that it was, so we can't infer that he was there for a malicious purpose. She doesn't mention if he's got anything in his hand, if he's coming to fax something, if he's got a file. She doesn't say what he did when he got there. Did he get a file? Did he use anything? She doesn't tell us what days these happened. She doesn't say anything about what as an example, what his clothes were. If he talked to her, she doesn't say what it was he said. This is probably the fewest pieces of fact that ever could be assembled in connection with this case, and that's why in the dissent says there's got to be something here, and I dissent. I think the statute of limitations has expired. She has not done anything to overcome the showing. And in fact, if the only thing that you have is that he came close by walking to get to do business, and it happened to be early in the day, is he required not to show up? And remember this, at this point, she's never complained about harassment to anyone. She's never said boo about this, and allegedly over 5 years, 7 years, whatever it was that this harassment is said to have occurred, and we take it as true for summary judgment purposes. We're not arguing that point. But as someone who's never complained about harassment, you do have to overcome the fact that he has legitimate business reasons for being there. And then that kind of now gets...
Counsel, you may sum up. You're over your time.
Oh, I'm sorry. Well, then can I reserve? Well, I do want to say with regard to outrageous conduct, the only thing the Court of Appeals looked at was information that came before any of the dates. The last time any discrete happened was in March, and yet they focused on that. I'll reserve the remainder of my time. Thank you.
Mr. Pohren, thank you. Mr. Denne?
Thank you, Your Honor. May it please the court, counsel. Again, my name is Jay Denne, and I represent the plaintiff in this case, Joni Cote. The E being E on the end of my name being silent, and the E on the end of her name giving a pronunciation, intricacies of language, which is why we're here.
Counsel, would you begin where we left off on this statute of limitations
Sure.
issue? I noticed in your brief you assert that there were acts within the relevant limitation period, and would you focus on that at the outset of your presentation, please?
Absolutely, I can. Thanks, Justice Hecht. I will address it by noting just a little bit of background on the law. Of course, the background from both this court and from the federal courts that have addressed these things, saying you take hostile work environment cases in their totality, you only need one incident or one act within the 300 days. So you've got from 2005 to June 14th, 2012, I think is the 300-day marker, if I'm not mistaken. I think that's in the record. So you've got several years of incidents, the first few years being directed to coworkers, then several years of incidents directed at her. And then the question, I think, then is what occurred after June 14th, 2012. So that is addressed specifically in her affidavit in support of the resistance to summary judgment, as well as her Iowa civil rights complaint language, which was relied on both by the district court and the Iowa Court of Appeals. So you've got an MO of a gentleman walking in before there's anybody else in the office, standing next to her with an obvious erection with the intent, I think it very definitely can be inferred, with the intent to offend her or to create a sexually hostile work environment. So you have, after June 14th of 2012, up through August of 2012, you have several occasions in the early morning, no one else was there, same MO. Wander in the work area, sometimes to ask something, sometimes not saying anything at all. Mr. Pohren gives what I think is a very interesting and a perhaps successful closing argument as to the distinctions, but did he have a legitimate reason to be there or not? That's for the jury to decide, not for the court reviewing a summary judgment motion.
Give us a little more flesh. I think it's clear, and just as I invited counsel to correct me, I invite you to correct me, but I think it's clear that if his mere presence at the place of business wouldn't be enough to defeat the 300 days, then I think you'd agree with that.
Right.
You got to do more than that.
Right.
And I think you'd also agree that the record shows that she didn't specifically observe, directly at least, sexual exposure or erection at all. So the question is, where do you draw the line between mere presence, which we all agree would not be an act that would survive the 300 days, and yet you have an appearance in the office but no express sexual contact. So why is this closer to you get to try it than it is to no, it's too vague, we're going to toss it out?
Right. It's a very good question. Again, number one, because of the past history. Number two, because, again, reviewing her testimony, there's no, Mr. Pohren didn't take her deposition in order to clarify her
You got the
practice
burden,
evidence.
so
Right. Well, of course, it's always our burden, but I think it's, well, the facts in the record are interpreted in the light most favorable to us, unless he can show otherwise. So you've got her testimony. Again, this is a quote from the Iowa Civil Rights. Kevin, meaning Dorn, would come wandering around my work area, either asking me about something, not saying anything at all, same scenario. I immediately feel my body tense up and try not to look at him. I'm confident he is displaying himself like always because I can tell by his demeanor. So this isn't an abstract question of philosophy, like, you know, if the tree falls in the forest and nobody's around, does it make a sound? Or quantum physics, where you got Schrodinger's cat, where he put the cat in the box and it's unobserved. Is it alive or dead? We don't know. Those kind of metaphysical questions, philosophical questions. Here we have a specific pattern of behavior that she interpreted as being further intents to harass her.
Let me try and kind of focus in on what I think the heart of the issue is. Your position is a reasonable juror could come to the conclusion that even though she didn't see him exposing himself, he was doing so. Is that your position?
Right. That she doesn't have to look.
Short of that, you would have a problem, right?
If I understand your question correctly, if she didn't have based upon history and based upon the circumstances of him coming in the office and her interpretation of it, if she had no reason to believe that there was anything going on, sure, yeah, that would not be a violation.
Juror, not just her, but a reasonable
Right. Reasonable juror,
right?
yes. Right. Reasonable juror based upon what she is taking from these incidents from June to August 2012 in connection with the entire course of the event. Yes, reasonable juror, absolutely. So, if there's any other, I'd be happy to address more questions on that issue. Otherwise, go ahead.
One other question, just sort of a follow-up. Could you illuminate for me, for the record, what is shown with respect to the frequency with which Mr. Dorn was doing this conduct, where he prior to June 14th, 2012? How often was he exposing himself in the way that you've already described? And the reason I'm inclined to focus on that is the enterprise we're engaging in is a determination of what is a reasonable inference from his past conduct. And it seems to me that our job necessarily takes into consideration how established was this pattern of conduct prior to June 14th, 2012.
Sure. I'm just looking at appendix, if I'm reading these pages right, 106, 107 out of the appendix. It looks like it started in 2007. If you go to paragraph 15 of her affidavit, it talks about for the next several years, Kevin did the same thing several times per year. And goes on to give some specific examples of incidents. She talks about two specific incidents in February 9, 2012, March 12, 2012. So I think the inference was occurring often.
Okay, on the family issue, we're in Iowa. We've got lots of small corporations. We've got family farm corporations. Just about every farm is a corporation. We've got lots of small businesses, frequently incorporated, lots of S corporations. You think the legislature really intended to eliminate the family law exception for the entire range of corporations?
I believe that what they meant, if they would have had that, if they would have intended to say that corporations can have family members, they would have defined, well, you're going to look at the shareholders, you're going to look at the officers, directors, same kind of analysis that the Court of Appeals did. You can come up with all kinds of scenarios about, are you including this shareholder but not that shareholder, this officer but not that officer?
That would have been a lot better, no question about it.
So I think in the absence of that, in that silence, I think, again, you look at this in the backdrop of 216.18 sub 1. This chapter shall be construed broadly to effectuate its purposes. So I think if this is ambiguous, we get the benefit of that ambiguity. You go to the definition of person then, too. It talks about individuals, partnerships, associations, corporations, legal representatives, trustees, receivers in the state of Iowa, all political subdivisions and agencies thereof. You know, the state of Iowa doesn't have a political subdivision, doesn't have a family member. I think if they wanted, again, going through the analysis that the Court of Appeals did, and I think its analysis of the Burwell versus Hobby Lobby decision is really spot on, and because even the Burwell case noted that sometimes, you know, person can mean artificial person, sometimes person means individual. So in this case, you know, an artificial person just can't have a family member. There's sometimes in the Civil Rights Act it talks about gender assigned at birth or familial status. You just a corporation can't have that. An individual can. I think it's kind of goes back to that general analysis of that was alluded to before, of going back to what the legislator might have been thinking. Hard to think 40 yees ago. I had Professor Bonfield in law school. I'd love to go back and ask him, but I haven't talked to him for 25 years. And
Don't worry, we have. But let me ask you a hypothetical. What? I was just joking. I mean, certainly we haven't talked to him about this case. So, what if Kevin and Patty Dorn owned the business as a husband and wife partnership? Where would you land then?
Partnership versus a corporation. Again, I don't. A partnership is not still is a legally distinct entity. It doesn't have the benefits in terms of liability, protection, and things like that of a corporation, but it's still, partnership doesn't have a family member.
As an unincorporated association.
Unincorporated, if I understand what, again, I think anything other than a individual person would not be covered.
Proprietorship would be the only
Right.
one that works. Okay.
Right. I think that the Huebner case talks about, it looks at a UIM policy. There's no family coverage for a corporate policy holder. Corporations can't have family members. And I don't think...
Are there any states with similar statutes that have addressed this specific question?
I've looked too, and I have, like Mr. Pohren, I couldn't find anything either. So I think, I think I've covered most of what I wanted to cover here. The question, the kind of the subsequent question that Mr. Pohren alluded to hasn't been in terms of the grandniece. That because of the ruling on the corporate status, that wasn't addressed by either the district court or the Court of Appeals. So I don't think that that's squarely before the court. If it goes back, that would have to be looked at.
What about the niece? I mean, should this, if we have to define family member, clearly a spouse, clearly a son or daughter, but what about a niece, or is it limited to nuclear family, and how do we decide?
That's where you go back to, I think, where Professor Bonfield is instructive. And if I can find his language, which I wrote down somewhere, close, intimate, and this is actually, you cited this, the Supreme Court cited this in Baker, close, intimate, personal, constant association. I think that that's a very fact-based inquiry, which, yeah, nuclear family living together would certainly apply. Extended family, most likely not. It could under certain circumstances, which I don't think apply here. I think I'm about up with my time. I don't have anything else unless there's any further questions.
Mr. Denne, thank you.
Thank you.
Mr. Pohren, you may present your rebuttal.
There's never enough time for rebuttals, I'm sure, but I'll be as brief as I'm allowed to be. One of the things that is very troublesome to me as the defending attorney in this case is I'm looking at a trial court that says, if this case comes back and is tried, it is up to the plaintiff to show that there was an actual exposure element that takes place during this 2-month period, June and July. And so I look at that and I say, if that is what the trial court believed, then why didn't this case get bounced at the trial court level? Because that's not evidenced in any way, shape, or form in the evidence that was presented by Ms. Cote. I look at the Court of Appeals, and the Court of Appeals has a different flavor to it, and the Court of Appeals opinions, it doesn't suggest or imply, it actually kind of says, it is enough for him to have simply been walking in her area at that time of morning.
There's one sentence that kind of makes that suggestion as I read it. But
and
there are
that-
other sentences that don't, and I think Mr. Denne concedes that's not the standard. So I'm really more interested in the other issue, the family member issue. I mean, again, I'm still troubled. I know I'm repeating myself. I'm still troubled by the notion that a corporation can have individuals who are members of its family. That doesn't seem possible.
And I think the same could be said, Your Honor, about trusts, about partnerships, about any of those entities. I think the task for this court isn't to try to find a bright line rule like that. I think the task of this court is to say each of those entities could have family members, and the question for the court is not different than what Mr. Denne also suggested, and that is you analyze who is the owner, and you determine from who the owner is, the nuclear family, if that's sufficient, and then we move on. Those are the family members.
But shouldn't it be conclusive that the person who files the employment withholding tax return, or the entity, is the employer, and there's no question here that the corporation would file it, not the individuals. Now, when you have a partnership, a partnership is just talks about debts and liabilities, and you may have a family member. But there's no question in this case that a corporation, even though it's a sub-S, files a return showing that these are my employees. And I don't know, again, I'm sort of lost like Justice Mansfield. When you do that, how do they become a family member?
I think we look at these in terms of a bright line, and I see where the bright lines are. The trial court found one, and the Court of Appeals found one, and you may find one too, but I don't think that's your task. I think the Court of, when I look at the statute, I look at this in its totality, and I look at 6A, and it has a part here that talks about individuals who are members of the employer's family. It's very clear the legislature knew when to use individuals and when not to. And it could have easily been said, for purposes of this section, individuals who are members of an individual's family shall not be
Are there any
counted.
states that allow the family member count, or even the federal law, if it's a closely held corporation?
No, I'm not aware of any. I know the federal count is based on the number of employees being 15, as I recall it correctly.
Is there any statutes written differently where they say family members of closely held corporations are not counted?
I'm not aware of it. I can't say I know every 50 state. I would be untruthful if I said that.
This case, it might be easier if, in that there's one owner, but what if you have a farm co-op with dozens of owners and only, grain elevator with only a few employees, but the employees are family members of some of the owners? What would we do there?
I think it's that same case-by-case analysis, Your Honor. I think
That's sort of a reason not to go in your direction. I mean, I know you want us to be Columbus, but if we go this other way, the Nina and the Pinta and the Santa Maria can all stay home, right?
You know, it's wonderful to know that all the courts have some sense of humor, and
To 3 days of arguments.
I agree. Well, Your Honor, I would just ask you, when you look at this, how would you then, when you look at subparts B, and then you look at subpart C, and you apply the same analysis to a corporation, you can't do this unless it's a sole proprietorship, you are constricting greatly all of those exceptions. I have tried to set out in our application to the court a way that gets done, and I would urge the court to try to focus on how to make sense of the law and apply it, and not have a categorical rule that says because corporations can't have babies or family members, therefore these don't apply, because then you greatly restrict what the legislature was trying to do under A, B, and C. Thank you very much. I appreciate your time.
Mr. Pohren, thank you as well. Mr. Denne, thank you again. The case of Cote versus Derby Insurance Agency is now then submitted to the court, and I'd ask the bailiff to adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.